I am Nicole Smith. I am the Event and Communications Coordinator for Spark Niagara. And this is a weekly webinar that was, of course, delayed as from last week. We are so thankful that you were able to join us today. And I thank our presenter for being willing to join us so short notice, but be able to come on today on Tuesday. We are so happy to be able to provide these weekly webinars to everybody in partnership with the Niagara Falls Small Business Enterprise Center, as well as the Niagara South Chamber of Commerce. So it is our thrill to be able to do that. I am so happy to introduce our presenter today. Her name is Natalie Raffoul. She is from Ottawa. She is an expert in intellectual property law. She deals with this day in and day out. She likes it so much, she's even joined groups and committees that deal with that, especially on the governmental end. So we are so excited to have you join us today. And I am just going to hand this over. Before I do, everybody notice that you are on mute, and we ask that you remain on mute for the presentation to try and cut back on the ambient noises so that it doesn't interrupt Ms. Raffoul's presentation. Also, if you have a question, we will have a Q&A at the end of the session. So feel free to write your question in the chat box, and we will make sure to answer all of those questions before we leave today. And without further ado, I'd like to hand this over to you, Natalie.
Thank you so much, Nicole. Really excited to be here today. Sorry about last week. It turned out to be an internet outage from Toronto to Montreal for an hour and a half, just over that period where I was supposed to deliver this talk. So I'm so glad that you were able to join this week. So hopefully you can see the presentation. So we're going to talk about intellectual property considerations. I'm assuming that most of you are either entrepreneurs or interested in starting companies or maybe involved with companies where you want to understand more about what are some of the important intellectual property considerations, and particularly nowadays, as we move into, and I'll talk a little bit about this new economy and how really the world has changed in the last 50 years, and a lot of the policy decisions or a lot of the economic policy that was set in place decades ago needs to shift in light of where the economy is going globally, not just within Canada. So we'll get into a little bit of that. Just a little bit of background on me. So I am the managing partner of a firm called Raffoul that I established 12 years ago now. Time flies. I'm a lawyer as well as a Canadian and US patent agent. I practice very actively before the US Patent Office as well as the Canadian office for a lot of Canadian SMEs, universities, government organizations such as defense and various others. My background's in electrical engineering, and I used to do a lot of telecommunication work back probably 20 years ago, a lot of Nortel work, and that's evolved into doing a lot more software work these days, and doing a lot of patents sort of in the cutting edge, artificial intelligence, cybersecurity, a lot of social enterprise as well, social networking, so in just kind of various kind of cutting edge domains. And a little bit also on the personal side, I'm also a mother of 3 children too. So I get it for parents out there who are also, getting into this whole entrepreneurial life. It's not easy, but it's very fulfilling and very rewarding. Another thing that I wanted to say at the outset was, I am a lawyer, and I will be providing you with a bit of an education on IP and IP considerations, but I am not your lawyer, and every situation is different. I'm always happy to entertain questions. So after the presentation, feel free to be in touch over email, and I'd be happy to answer questions for you that may be particular to your business. And of course, if we decide to work together, that could be a possibility as well too. But please keep that in mind that these are general. This is sort of general advice, but there's always a nuance, and particularly in law, there's always an exception. There's always an exception to the exception. So it doesn't always apply to your particular situation. Moving on here. So what is intellectual property? Because I think one of the things I keep harping on, whether I'm talking to policymakers or I'm talking to entrepreneurs, is just getting the terminology right. I often get people coming up to me and saying, "Oh, I'd like to trademark that idea." So it's really important to understand when you're talking about intellectual property, what are the different types, and also understand, well, what is it? So IP really covers a large swath of what we call property rights, and it refers to those rights that stem from creations of the mind. So when we think about intellectual property, it ranges from inventions to literary and artistic works, to symbols, names, images, designs that are used in commerce, circuitry designs, domain names. So anything that is sort of originating that is part of kind of what we call that intangible asset category. And under intellectual property law, generally speaking, what IP gives you, what IP protection will give you is certain rights that are exclusionary, that enable you to exclude others from potentially the use or the ability to sort of sorry, I'm at a loss for words for this, but sort of exclude you from using, I mean, I don't want to get, I'm thinking of trademarks versus patents here, but it gives you the exclusive rights to a variety of tangible assets. And so we'll get into a little bit on what that means as I dig into some of the forms of intellectual property. So next slide. So IP and data, really today, when we talk about where the value resides in companies, it really is in the intellectual property and the data. And whether we're talking about a restaurant or we're talking about a social media company or we're talking about a mobile phone company, and whether we're talking about patents or we're talking about your brands, your assets in your business are really going to reside in that intellectual property. So for example, if you're a restaurant, how much value resides in the goodwill and the trademark that is associated with the restaurant. So, or if it's a mobile phone, how valuable are the patents associated with some of the chips that you design for your mobile phones? And really, we really see an evolution of this in terms of where the value resides. And we know today that the digital transformation over the past 30 years has resulted in a new economic reality in which the basis really of wealth and power is derived from the ownership of valuable IP, and more recently, the accumulation and control of data. And IP and data are now the world's most valuable business and national security assets. And I invite you, if you're curious in terms of, okay, what is, what sort of is the state of Denmark in terms of intellectual property and data and the value that we're associating with it today, I invite you to take a look at the report that was issued. I was part of an expert panel that came out with a report in February that looked at Ontario's innovation ecosystem and presented sort of what is the state of Denmark in terms of IP, in terms of how we're doing on that front. And I really invite you to take a look at that report and some of the recommendations that we made if you're curious in terms of the policy side of this as well. Just to give you a sense of what I was talking about, if we look at the S&P 500 and we take a look at the market value of those companies, in 1975, you only associated about 17% of the value to the intangible assets, to the intellectual property and the data that a company had. Nowadays, we associate 91% and even higher than that if we're now moving forward into 2020. Over 90% of the value in the company resides in the intellectual property and the data that that company holds. So that is an incredible shift. And so when I talk about the new economy, I'm talking about this shift from our valuations of companies being, stemming from, okay, how many barrels of oil do you have? How many bales of hay? How many products do you have in a warehouse? To really, to a point now where we're saying, what's the value in your brand? What's the value in the data that you're collecting on your customers and your users? What's the value associated with those patents that you hold? So there's really been a massive shift. And you see that nowadays, even when you look at the stock market. I mean, where does the value reside? We look at the FANG companies, right? The Facebook, Apple, Netflix, Google. We look at that slate of company, we look at those valuations, and what are we talking about there? Those companies are not, not warehousing physical things. They are technology platforms where really the value for them resides in that data and in the patents that they hold, in the value around their trademarks. And just to give you a sense of where this is all going, so I was asked to sort of speak to what's sort of this, again, this, I come back to this sort of state of Denmark, but asked to speak to you a little bit about how things are going and how Canada might be positioning itself in this new economy. And one of the things we talk a lot about nowadays is artificial intelligence. And so WIPO, the World Intellectual Property Office, issued a report in 2019 on artificial intelligence patents and on the trends in that area. And one of the things you'll note is who owns what, and as I show you, come to the next slide. But IBM, interestingly enough, which is the largest patent holder in the world, they have the most patents, whether it be US or globally. They have already, as of last year, about 8,300 AI patent applications. So patent applications related to artificial intelligence and machine learning. Microsoft has the second largest portfolio of patent applications and now patents, because as they move from pending to actually being granted as patents, these two companies hold a very significant portion. And what's interesting to note is 26 of the 30 largest portfolios are owned by corporations, not by sort of state government agencies or research labs or universities. They're owned by corporations. And as we know, artificial intelligence is going to be very important technology in the future in terms of the advancements are all going to be, most advancements will be underpinned by artificial intelligence and machine learning, as you probably know. So have a look at these statistics here that we're now already are about a year old now, but again, it shows you who are the top players in this space in AI, and the numbers of patent applications that they are filing is incredible. And what we see here is, 12 of the top 20 companies are actually Japanese, which is interesting given, how advanced they are. Toshiba and Toyota and Fujitsu and Hitachi, these companies are pushing hard on the R&D side, but they're not just doing research, they're actually patenting it at incredible rates. 7 of the top 20 companies have acquired AI-focused companies, so we're seeing we continue to see a lot of M&A activity in the AI space, larger players buying smaller companies that are doing research and development and productization in the AI space. Including some of our own companies. Alphabet itself, Alphabet is the holding company for Google, has acquired 18 AI companies as of last year. So these trends are incredible. What's also interesting to note, and this was, this graph is taken right from the WIPO report, is WIPO's highlighting for the most part globally, it's companies that are owning patents in the AI space. But for the Chinese, it's actually their state-run agencies. So if you look at the Chinese Academy of Science, they are really very active in the patenting space. If you look at their ETRI Institute, again, the Zhejiang University in Beijing, so they are, as a country, they're taking more of an institutional focus in terms of filing for patents versus other countries such as the Japanese and the Americans and the Germans are taking, it's more the corporations that are filing for patent protection. So, interesting to note that. The annual growth, the other thing to really note too is, for example, the State Grid Corporation of China grew on average the filings by 70% last year. So we're seeing a lot of activity out of China in this space. So in the cutting edge spaces, we are seeing a significant increase in patent filing that continues this year as well. So just something to note that in these spaces, and these are software patents, right? So what kinds of things are they patenting? They are patenting algorithms, and they're patenting algorithms for particular application, but these are software patents. So it's just something to kind of highlight for you. And then the other thing is, sort of where does Canada sit in all this? Well, Canada is on a downward trend, which is not great, and we're hoping that that's going to improve. But in terms of one of the metrics we look at is for our Canadian companies and institutions, are we filing what we call PCT international patent applications, which is a marker to say, are Canadians filing for patent protection internationally so that they protect what they're doing in global markets? And what we're seeing is Canada is actually on the decline. And from a sheer numbers point of view, Canada actually has, as a percentage, we're very low when it comes to patent counts, and we're on a downward slope when it comes to further filings as well. So this is one of the things that has come to light for the policymakers at the federal government level, as well as the provincial governments, particularly in Quebec and Ontario, And both Ontario and the federal government are in the midst of an IP action plan, and I think a lot of initiatives are being put forth to really sort of change this, because if we want to remain competitive, we're going to really need to make sure that we are sort of trending in the right direction. But just gives you a sense of where we fare on some of those metrics. So another thing to keep in mind too is that the evidence is sort of, there's empirical evidence out there to support the fact that intellectual property assets such as patents and trademarks really make a difference to your valuation, to how likely you are to export as a business. So one of the things that we know, and one of the things that I'm going to put out there is, for example, only 2% of Canadian SMEs hold at least one patent. And there's data out there that says really that number should be at about 6 or 7% really for Canada to be ensuring that it is capturing its intellectual property and to be avoiding the kind of IP leakage that we see today. So we really need to get that marker way up. Right now it's at about 2%. We really should be aiming for about 6 to 7%. And only 59% of our companies are even slightly aware of patents, which is a shame. But what we do know is that for those companies that are filing patents, we know that they actually are, more likely to see growth than those that are not. And why is that? Probably because going through the exercise of filing for a trademark application or filing a patent application forces you to do a little bit of due diligence and ask yourself, well, what would I patent? What is unique about what I'm doing? What are my competitors patenting? What is it that I do that really gives me that market edge, or really creates that market disruption? And same thing with trademarks. What is it? What is my brand? Is it any good? Is it distinctive? Is my brand or the trademark that I'm using, is it confusingly similar with someone else's brand? Such that maybe down the road I actually might not be able to use that trademark because someone else has prior use rights. So forcing yourself to go through that, what I call IP strategy and IP due diligence, and actually file for protection, it's a certain amount of due diligence that really I think puts you ahead. And we see that empirically, that companies are 2, 3 times, 4 times more likely to grow, to export. We know that those that hold IP rights are 4 times more likely to export globally. And valuations are going to be 4 times greater for those that hold IP assets. So just by holding a trademark or a patent, you're really ahead of the game, and your valuations will be significantly higher. So to accelerate Canada's leadership really in what we call a data-driven research and innovation economy, we're going to need a framework that supports domestic innovation. And that's why I'm so keen to talk to speak to incubators and to speak to entrepreneurs such as you. Because really this is where the focus has to be. We have to focus on our domestic companies and make sure that they have the tools to succeed, because we know that the value is really going to reside in these areas. And so how do we increase those valuations? How do we help companies in order to be able to compete really in a global market? And so Ontario, just to give you a sense of what I'm working on outside of my day job, but as an expert panelist, we're now moving into an implementation phase. And what we're moving on to do is create a standardized governance framework for all support organizations, so research institutions, incubators, accelerators, any institution, and make sure that there is a governance framework that is more standardized, because what we see across the Ontario ecosystem is that different institutions are doing that differently, and that really should be standardized, because we can't really measure something that is not standardized. We want IP education to be disseminated across the province, so we're focusing on that. We're also going to be creating a centralized provincial resource with significant funding that will help companies such as yours get the kind of IP advice that you need, that is unbiased, so that you know what you need to do if you need to speak then to an IP professional. So developing a centralized resource, because what we're finding is across incubators and universities and colleges is that some universities have access to some resources, some don't have any resources, and it's not consistent across the province, and we need to really centralize and provide a resource that's available for everyone, that provides high quality, excellent advice to our companies. And when we look at some of countries that would be comparable, such as Germany or Singapore, they've done this. So you have the Fraunhofer in Germany, which is a centralized institution that provides excellent IP advice across 72 institutions in Germany. Singapore has its centralized intellectual property office that's doing the same. So really provide that central resource. And then all commercialization entities that are focused on helping companies commercialize, that they have very clearly defined mandates. And then also for us as experts to provide an IP lens for the Ontario government so that we ensure that as we're putting together programs, make sure that we're thinking about intellectual property. It's been really an afterthought to date, and we want to make sure that it's not anymore. So Canada's IP Action Plan, just really quick before we launch into the IP, is the patent collective would be focused on, there's a patent collective that's been started that's really focused on clean tech and data-driven technologies. We're hoping that that's going to be broadened out to other areas. There's also a plan from the federal government that's been rolled out, and they're continuing to improve upon that for IP education across the country. And most recently, this was just a few weeks ago, the BDC announced $160 million of funding so that if you do have intangible assets such as patents and trademarks, that you can actually secure financing against those. So this is an exciting development. There's going to be more initiatives to come. So let's get into, as I said earlier, let's talk a little bit about the types of intellectual property and get more into the details around IP. So for example, patents. Patents protect inventions. And quite some time ago, probably going back 100 years, there were a lot of patents filed around bottle caps. Different types of bottle caps that maintained the gas within the bottle for fizzy drinks. And so this would have been the subject, these types of inventions would have been the subject of patents. If you look also, at this Guinness bottle, the Guinness trademark. So the Guinness trademark, it's a brand, it's a very famous brand, it would be protected by a trademark. There's another brand on here, the harp. When you see a harp on a bottle, even if you didn't see the words Guinness, if you saw that on a beer bottle, that would probably evoke that's a Guinness beer, even if you didn't see the Guinness beer. So trademarks can also be, they can be logos, they can actually be sounds, and we'll get a little bit more into trademarks, but it gives you a sense. Copyright covers the expression of a particular idea, expressive work. So the way this bottle is designed, the writing on the back, all the particular arrangement, the oval with the wording, that would all be protected by copyright. Design. This bottle isn't particularly distinctive in terms of its design, but if you think about the Evian water bottle with its glaciers at the top, that, for example, would have been the subject of an industrial design or design protection. So you can protect the look and feel of a particular item, such as the body of a car. If you think about it, cars have very distinctive look to them. Those can be protected through designs. And then trade secrets are confidential information within your company that you maintain as secret. In order to have trade secret protection, though, you should be putting in processes in place to maintain those as secret, because there is a requirement. If you're ever to assert that you had a trade secret and there was a trade secret theft, you need to show that you're actually maintaining it as secret. So who has access to the trade secret, etc. Domain names, of course, Guinness.com would be a domain name, but there are many TLDs. There are, you could have Guinness.biz, .ca. So these are domain names, and there are certain rights that are associated with domain names. Trademark holders. So if you actually have a registered trademark, you have advantages when it comes to cyber squatters. So if someone has registered your trademark in one of these TLDs, you have sort of advanced rights if you actually have a registered trademark. And there are other forms of intellectual property as well, such as integrated circuit topography. So you're able to register 3D configurations of circuits. What is becoming more popular also is plant breeders' rights. So now we've got all these, cannabis varietals. So you can register those particular varietals under the Plant Breeders' Rights Act. And there are, that type of protection is known internationally. So this is just kind of an image. I like to sort of touch on software a little bit because I had an interesting conversation with someone yesterday saying, what, you can patent software? I didn't know that. So yes, you can patent software. You've been able to patent software, what we call computer implemented inventions, for decades now. And I thought it'd be interesting to just kind of walk through Instagram as an example. So Instagram, if you look at the source code would be the subject of copyright protection. So the way you code something, not the ideas itself, but the actual code in its particular language, that would be protected by copyright. Trade secrets, of course, a company like Instagram would have secrets, would have particular secrets. They might have, some of their agreements might be secret. Their client information might be secret. Some of their algorithms that are not, clearly, clearly understood or sort of readily detected from the outside. So sometimes with an algorithm, you know what the algorithm is doing. You don't even need to actually see the algorithm actually written out or get behind the wall or understand. You know what's going on inside the black box. But other times the algorithms are quite complex and you don't know what's going on inside the black box. For patents, this is actually an image taken from a Facebook patent that could actually cover an Instagram application. But as you know, Facebook owns Instagram, but maintains Instagram as a trademark holding of Facebook. So here's an image of a flow chart from a Facebook patent. So lots of things that Instagram is doing may be patentable, such as the architecture, software and hardware interactions. What is happening? I mean, Facebook has actually got a patent on the like button, sort of the notion of being able to provide an emotion through a particular image and to be able to select or deselect that. So that concept was quite novel at the time, and that's patented. Industrial design. So for example, the look of a graphical user interface. I always say to clients that are in the software space, have you thought about design protection for your GUIs? Because your user interface can have a very particular design to it. If you think about Google's landing page, with the rectangular bar, very distinctive with the buttons, I'm feeling lucky. You can actually protect those through a design. And then trademark, we're very familiar with that as well. So patent basics, and this is kind of coming back to what I was sort of stumbling on my words earlier, but what does a patent give you? A patent gives you the ability to limit someone else from using your invention. So it is a limited time monopoly, and it enables you to prevent others from working your invention, but it doesn't actually give you the right to do anything. This is something that people get confused about. So for example, if you came up with a drug, sort of a compound, for use in treating X disease, you wouldn't actually be able to just go out to the market and start selling that compound. You need to go through regulatory hoops in order to be able to sell your product. You may need to go through some safety requirements to sell your product. So the patent doesn't give you the right really to do anything. A patent enables you to prevent, for example, a generic pharmaceutical company from actually making, using, importing, or selling your claimed invention, so your patented invention, for a limited time. And typically patents run about 20 years. What do patents cover? What is invention? So this section is taken out of the Canadian Patent Act, but the Canadian Patent Act is modeled after the US Patent Act. So this definition in the US is fairly similar, but basically an invention is something that is new and it's useful. And it's either an art, a process, a machine, manufacture, or composition of matter. And this is a very broad category. And in fact, one US Supreme Court justice once said, everything made by man under the sun should be patentable if it's new. So, over the years, what's happened is courts have said, well, what is process? What is machine? What is manufacture? What do those broad terms really mean? And as technology has evolved, the understanding of what those broad categories mean has evolved. So when we think about software would fall under process, or if it was implemented by a computer, software is implemented by hardware. We also talk about software falling under the category of manufacture, right? Because it is actually something, or it's a machine, for example. So it falls under these broad categories. And so examples of things that are patentable, packaging material, vaccines, mechanical equipment, computer hardware, software. So all these sorts of things are patentable. What are the patent basics? So when I say new, it has to be novel, so it can't have been disclosed anywhere in the world by anyone. It can't be obvious, and so obviousness is a little bit more of a less clear term, and it has a different, obviousness takes on sort of it has different parameters around it depending on the country you're talking about. But basically, you can think of it as if your invention is described in 2 documents and it would be very easy, or someone, there's motivation for someone to combine 2 pieces of information together, then that would be considered obvious. And then it has to be useful. And then coming back to the broad subject matter category, we talked about this just now. The subject matter is it a process or an art or machine or composition of matter? There are some exclusions. You can't patent abstract theorem. You can't patent, in some countries, there are public policy dictates that you can't patent things that are illegal or that are obscene. So there are, depending on the country, there are certain parameters around that. But basically, the way I would think about it is if you've come up with something new, I tell clients all the time, if it makes something run faster, if it's somehow better in some way over what's out there in the competitive marketplace, or it's cheaper, then you probably have some kind of invention and it's worth exploring. Just to give you a sense of kind of patent filing dates, and just to kind of understand how the system works. So you don't have to, so patents are jurisdictional. If you get a Canadian patent, that doesn't give you any rights in the US. So if you want to protect your invention in the markets where you're operating, you need to be patenting in those jurisdictions. But the nice thing is you don't have to patent everywhere at once. So based on the Paris Convention Treaty, there is a priority system that dates back over 100 years that gives you the ability to delay filing in other countries, provided that you file in a country that is part of the Paris Convention Treaty. And most countries that are part of the World Trade Organization, and that would be pretty much everything to the exclusion of a few islands, are part of the World Trade Organization. And so you can feel very confident that if you file, for example, your patent application first in Canada or in the US, you have a year before you need to file in other countries. And so that's what this shows. And you still get the benefit of that earlier filing date. And this can be really helpful, whether you're a small company or a large company, because when you first conceive of an idea and okay, this is how we're going to build it, you're not going to be in the marketplace right away. You're not going to be making money from that invention. And there may still be some more refinements to come, improvements to that. And so by filing just in a single country at first, you are able to, first of all, add subject matter over that course of that year, and also see if this is actually going to be successful in the marketplace before you start filing all over the world. The other option, and this is a strategy, and whether you're a startup or whether you're a big multinational company, a lot of companies will take advantage of the PCT process, which stands for Patent Cooperation Treaty, which enables you to file first in the US or first as a PCT application, and then in 30 months file in all the countries that are signatory to the Patent Cooperation Treaty. So this is a great cost deferral strategy, and typically what my clients will do is we'll file what we call a US provisional patent application first, and then in a year we'll file what we call a PCT international patent application, and that gives us 30 months to decide in which countries we want to file. There is no such thing as a world patent, so at the end of the day you do have to select particular countries. There is such thing called the European patent, but even in that case you still have to validate in the particular countries that you want to file in. So this just gives you a sense of timelines. So one of the things I wanted to talk a little bit about is assumptions that often clients will make. So it's really important to make sure that you're not disclosing your invention before you file for patent protection. And a lot of times companies say, oh yeah, I didn't publish it anywhere. But discussions with investors, your pitch decks, talking to consultants, talking to marketing people, talking to friends, that can constitute public disclosure. So again, what I said is, in order to patent something, it has to be new, which means you can't have publicly disclosed it prior to that. And there are grace periods. Of course, there's exceptions. So Canada and the US have a 1-year grace period for public disclosure, but I wouldn't use that because, for example, Europe and China, the other 2 very big markets, there is no grace period. So just keep in mind, no public disclosure before you get patent pending in at least one country. Oh, sorry. Another assumption that people make is that that your company owns the invention. Well, what do your employee and contractor agreements look like? Do you have everything in writing? Because the default actually is that inventions are owned by inventors. And so even though you might be paying for the development, someone, you have a software developer working for you, unless you have an agreement in writing that says that all intellectual property rights will be assigned to your company, including a waiver of moral rights, you don't own the intellectual property. So it's really important to make sure that you get employment and contract agreements in writing, not just a handshake, but actually ensure that your business owns the intellectual property, because a lot of companies are really under that misapprehension that the company owes it if they pay for it, and that's just not the case. In some countries, for example, in Germany, by operation of law, that the business owns the invention, but in Canada, it's not the case as well. So you need to make sure that you have that in writing. Another thing to keep in mind is non-disclosure agreements. So if you're going to talk about your invention prior to patent filing, you can make use of non-disclosure agreements. It's always best to be patent pending, because having to enforce a non-disclosure agreement, which is basically a breach of contract, and you'd have to prove that you suffered some damages from the disclosure of this information, which is not always an easy thing to do. But if you have to have some early conversations, make sure you have a proper NDA in place. Like who are the parties to that agreement? Is it you as individuals? Is it you and the other company? Is it the individuals and the companies that should be bound by the NDA? What does it cover? Are you required to mark everything as confidential for it to remain confidential? When does the NDA terminate? How do you get your information back? So how do you get your confidential information back? I find a lot of NDAs are not well drafted, and sometimes people are grabbing things off the internet and they don't make sense. If you need a competent NDA template, I'm always happy to provide those. We provide that pro bono all the time, but it's important to make sure that you have a proper agreement in place, because if you need to go back and rely on it, that's pretty critical. One thing to just keep in mind too, and I don't want to give you a little bit of a story here. It's a patent story and a little bit of a disaster that turned out to be a good situation in the end. But there was a company based in Toronto known as i4i, and this is going back 15 years at least now, and you can search that on the internet. But i4i was a software company in Toronto, and luckily they had actually filed for an early patent application prior to pitching their XML editor to Microsoft. When they went in to see Microsoft and they talked to some of the developers, they said, what do you guys think of this XML editor? We think it's pretty awesome. The Microsoft folks said, well, it's cool, but I don't think this is what we're looking for. I don't think we're going to make use of this. In the end, the development team actually did make use of the XML HTML editor, and it ended up getting incorporated in a number of versions of Microsoft Word. And the lucky part of the story is that this Toronto-based company ended up they got a patent in the end, a US patent, and they were able to get a venture capital company to subsidize their patent litigation against Microsoft. And they took this thing all the way to the US Supreme Court, and Microsoft did lose that patent battle. They had, they were making use of the patented invention by i4i, and it ended up getting to a point where it was a $450 million judgment against Microsoft, and also an injunction that was upheld that forced Microsoft to strip that editor out of their product in a number of versions of Word. So there's a couple of things to keep in mind here. Be very careful when you're talking to larger companies. Corporate theft happens all the time, sometimes unknowingly, sometimes knowingly. But you want to make sure that you're well protected. And this is kind of my point to NDAs versus being patent pending. If you've got really great technology, you might want to think about being patent pending prior to having a discussion with them, because to go back and say, i4i, for example, that they would have made a mint out of this invention, that's not always clear. So that's a tough case, but being able to go after them for patent infringement is a different story. It didn't require i4i to do anything or to show that they would have been a success. All they had to show is that Microsoft was infringing their patent. Industrial design, just to quickly speak about industrial design. So industrial designs cover various types of products. I wanted to show you kind of some examples that could be protected by designs. The iPhone, many of you are probably iPhone users. So, Apple, when they went up against Samsung in those disputes over patents, half of those patents actually were design patents. So, for example, the unidirectional slide to unlock your device, this was protected through a design patent. And I spoke a little bit about the Google landing page earlier. This is about to expire soon, but design patents in the US and what we call industrial designs in Canada will last about 15 years. So it's another form of protection that, particularly if you're in the software space, to think about. When you look at the Google design patent here on the screen, you'll see that some things are in dashed lines. That's disclaimed. So what Google actually protected here was a user interface with the words web, images, groups, news, and these buttons here, search and I'm feeling lucky, which, as you know, became very sort of, I mean, if you see a landing page with a button that says I'm feeling lucky, you're going to think that that's Google's, but in any event, they not only protected the I'm feeling lucky, as a trademark, but also this landing page is a design patent as well. Another assumption that folks make that I just want to highlight for you too is when you get into collaborative or joint venture situations with other companies. So it can be great to do collaborations. Your company really has core competencies in this area. This other company has core competencies in another area. So let's meet up and let's do something really synergistic. Problem is, if you come up with ideas together or you come up with designs together, who's going to own that? So it's really important to get those types of arrangements. Make sure that you spell all that in writing. If you are going to co-invent together, in the end, who's going to have the ability to file for patents if you want to? Who's going to own the designs? How does that work? Who's going to own the copyright? Even if you're not a tech-based business, who will own the copyright material? And you can get into a situation where maybe one entity owns it and the other one is just benefiting through a profit-sharing arrangement. There's always ways to deal with that, but best to get that clear and in writing earlier. The other thing to keep in mind too is that freedom to operate. A lot of businesses don't think about their freedom to operate, and that means, do you have the ability to sell your products and services in the markets that you want to sell it in? So for example, you might have a trademark for your product that's fine in Canada, but it might not be fine to sell that product under that trademark in China because someone holds a trademark right that blocks you. The same thing with you have a product that you're selling. Well, does someone hold a patent to that product in the market now that you're moving into? So for example, there might not be a patent in Canada that covers what you're doing or an aspect of what you're doing, but there's a US patent that's going to block you. So making sure that you have the freedom to operate and sell your products where you want to. And sometimes clients will get what we call patentability opinions. So we'll tell them how patentable we think their invention is, but that's not the same thing as figuring out whether your product, which includes your invention, isn't infringing on someone else's patent. And that's a different type of search. That's what we call a freedom to operate or infringement search, to ensure whether your product might have components to it that are already patented. So if you look at your smartphone right now, there are on average 250,000 patents associated with that device. So of course it's a minefield. Like, even though you might be building a chip in that doesn't mean that because you have a chip that can be used in a mobile device that you can actually now sell mobile devices. If you want to sell mobile devices, you need to get licenses to those 249,999 patents in order to sell that mobile device. Another assumption people make is that, so to do with trademark registration, is business name registration. So you've now registered your company name. That is not a trademark registration. We get that a lot from younger companies sort of getting confused because their corporate lawyer may have done a nuanced search or may have searched the corporate name. You are not necessarily cleared for your company name. Another thing to make sure is that if you don't bother with the trademark registration or get an actual trademark, when you go to Quebec to do business, you're going to have to translate your trademarks. If you do have a registered trademark, you can use your registered trademark in Quebec. So it's something to think about. Also think about foreign markets. So you know you can use your trademark in Canada, but have you checked to make sure that you can use your trademark in the US? There might be a business down there with a trademark registration rights that are stronger than yours. They've been using it for longer, or they have a registration that predates yours. So you need to be thinking about not just the Canadian market, but what is happening in these other markets. And so to kind of launch in here quickly to talk a little bit about trademarks and best practices. Once you've developed a product, how do you market and sell it? And so this is really where trademarks come in. And trademarks are so important, you know, regardless of what type of business you're in, because they help you connect with the consumer. You know, trademarks, they create some kind of emotion for the user, whether it's a good emotion or a bad emotion, but there's an association with that trademark and that product or service that you're selling. So they can create, you know, when you look at Nespresso, create that warm and fuzzy feeling. As soon as you look at that, you know, cup of coffee with the foam, and you see that Nespresso, the logo with the swish in it, it evokes something for you. So traditionally, trademarks were really, the key role for trademarks was to identify the source of the product. So the Dove mark identified the soap being manufactured by Unilever versus Johnson & Johnson. But we know trademarks do a lot more than that. They don't just identify the source of the goods, even though that's originally where they, you know, that's what the policy purpose was, to make sure the consumer knew where they were getting the products from. It really sells products today. So a trademark or brand can really be the key to your business success, and consumer recognition of that trademark leads to sales, as you know. So let's just get into some quick examples, which are fun. So Grey Goose versus Smirnoff. In the market, Grey Goose is always considered the leading vodka, but interestingly enough, when you do a blind taste test, and there's been a number of blind taste tests done that compared Grey Goose to Smirnoff, Smirnoff is always the one selected in the blind taste test, or at least selected more than Grey Goose. So it's interesting how brands can really be that powerful, even though, you know, arguably the vodkas are, you know, equally good. Here's another example of, you know, the power of trademarks. So the original, you know, media player was the Diamond Multimedia Rio PMP 300, which is a complete mouthful. Does anyone remember this this music player? No. But do you remember the iPod, and do you know the iPod? Yes. So just goes to show the power of strong brands. You know, and I was telling you about emotions, you know, even so something like barf detergent versus Tide detergent. So barf, I mean, you know, to a parent with messy kids, you know, barf detergent might be the kind of trademark that, you know, makes you select that product. So the objective of a good brand really is to deliver a clear message, to confirm credibility, to connect you with your target consumers, to motivate consumers to make a purchase. You know, we know that brands also create loyalty, trust, and they help you amass goodwill in your products and services. Trademarks can not only be words and logos, as you've seen already, but they can be colors. You know, the UPS, for example, has protected the brown. Louboutin shoes, the red sole, that's a color, the red sole for shoes. Figurative elements, the 3D shapes such as the Pillsbury Doughboy, holograms, sounds, scents, taste, textures, positioning. So if you think about Lululemon, that particular swoosh, where that's positioned on clothing. So there's lots of forms of trademarks. So, you know, and I talked a little bit about these examples. So even the smell, the scent of cut grass on tennis balls, the texture on a wine bottle. So these are the kinds of things that may be protected through trademark registration. Quickly here, so what would be your strongest trademarks? Would be things such as something that's not descriptive of the product at all, something that is coined or inventive and unique, such as Exxon, Xerox, Lululemon. These are words that mean nothing in the English language or any other language and are very distinctive and are really coined terms. So these are very powerful marks. What would be less powerful but still good is things that bear no relation to the product, industry, or field. So for example, Red Rose for tea, Puma for clothing, Apple for computer devices. Weak marks would be things that are just more descriptive, which have a clear connection with the goods or services. So All Brand for cereal, Chicken of the Sea for chicken soup. What is not registrable? So you cannot register the name or surname of an individual, but of course there's always exceptions. So if your trademark requires a certain amount of distinctiveness, if we think of Giorgio Armani or some of these clothing brands, you get to a point where you have that level of distinctiveness, you can trademark that. You also cannot trademark things that are descriptive or deceptively misdescriptive of your goods and services. So for example, foamy for shaving cream, or Mexican for tequila. Tequila is Mexican by default. It must be Mexican. Silkware, if for products that are not made of silk. So that would be deceptively misdescriptive. Searching. So another thing to keep in mind with trademark searching is that if you're going to undertake searching, especially if you're going to do it yourself initially, is it's one thing to do direct hits, but don't forget that things that sound the same but are spelt differently can also be considered confusingly similar. So you aren't just going to go ahead, if let's say you're selling computer products, you're not going to go ahead and come up with a trademark that is for Apple spelled Appel. I think Apple's going to take an issue with that, and even if it's for something similar. So keep in mind homophones, things that look similar or sound similar, that is also going to be a problem. So you need to, when you're doing search, you need to think along those lines. So for example, things with similar connotations, so trunk, safari, words that are mean the similar things in English language. For example, rabbit or hare, those would be considered confusingly similar. So when you are going ahead to think about where you're going to protect, think about where your markets are, where your competitors are, where you're manufacturing, and think globally in terms of protection. And also, one of the things I like to remind clients is that you don't need to wait to start marking your brands and your logos as trademarks of your business. When it's actually a registered trademark, you should use the R with the circle. But prior to that, you should start asserting in the marketplace that you view these things as a trademark, and actually put that TM symbol in the top corner of your brand. So it's either your logo or your word mark. Have that TM symbol up in there. And for the French, it would be MC marque composée, and then MD, when you actually have it registered, it's marque déposée. Just continuing on this vein of best practice, and I talked a little bit about this earlier, was just making sure that you are thinking about patentability, whether your invention is actually patentable, and doing those patent searches initially. So rather than just filing, taking a look to see whether you actually have a concept that's new. And in agreements that you make with other companies, be very careful about the warranties that you make. So if you're building software, for example, and you're saying to the company, yes, I warrant that this particular software does not infringe on any intellectual property. Well, how do you know that? You know, for example, that your source code is original, but do you know whether your software doesn't infringe on someone else's patents? So be very careful, because most clients are not doing patent searches every 6 months. So don't have warranties in your agreements, for example, in your software licensing agreements, that would warrant that you don't infringe a patent. Also, be careful if you're doing searching as well. What's the scope of your searching? What's the product scope? What's the geographic scope? Are you just searching in Canada, or are you looking globally? Being attuned to what exactly you're looking for is really important. Is this a global search, or is this sort of a domestic search, which is not necessarily as fulsome as you think? When you're thinking about filing strategy considerations, there's a number of reasons, for example, to file for patents in particular, and even designs, and to a lesser extent trademarks. But you do it for offensive reasons, because you know that someone is going to potentially infringe on your invention. It might be really easily copied. Or someone's going to your brand is going to be very popular, and so you're worried about someone making use of that brand. So that would be an offensive reason to file for protection. Defensive reasons are also because your competitors are already filing for protection. They have patents, they have trademarks, and so if they come to you and say, look, you're infringing on my patents, being able to have an opportunity to cross-license, or to say, look, I might be infringing on your patent, but you might be infringing on mine, gives you that ability to at least jockey in the marketplace a little bit. If you didn't have protection, you might not be able to do that. Also, for funding purposes, VCs, investors, government funding is tied now, and it's become more and more tied to having intellectual property assets. So it's important to be thinking along the lines for funding as well. And the other thing why VCs like it is because if your company isn't a success, the investor knows that at least they have those IP assets. For example, those patents might live on past a bankruptcy. So there is still an asset there. And when Nortel, for example, went bankrupt, back a decade ago, the patents ended up being the single biggest value asset on the balance sheet. They sold for $4.5 billion to a huge consortium. So it's just something to keep in mind there as well. In terms of, I'm kind of getting close to the end of the time. I've been talking a little bit too much here, but just thinking in terms of patenting as well, think about where is the patent infringement likely to occur? Who are your main competitors? Where might they be manufacturing a product? Nowadays, a lot is manufactured in Asia, so it's really important to be thinking about getting protection in Asia as well. The patent licensing economics, if you are a company that is interested in patents, patents really are considered products nowadays. And I talk, this slide just shows you a little bit about some of the valuations of some of the assets that have been sold from one company to another. And one of the slides I wanted to show you is, for example, in 2017 here, who are the top 25 patent holders at the USPTO? You can see IBM is just a runaway train here, but Samsung, Canon, and sorry, I'm flipping around here. In 2019, again, IBM continuing on with most patent grants. But it's interesting to see some of these other companies coming up. Huawei with 2,400 new patents in their roster in 2019. Taiwan Semiconductor as well. So, the Asian players are certainly amassing more and more assets. As a final commentary, one of the things I would say is, IP is about risk management. I mean, IP is basically legal risk, and so you're never going to get everything you want in terms of the agreements that you're putting together, but try to assess sort of low risk to high risk, and just keep in mind that there are certain things that are just going to be more important to risk mitigate, and others that you're just going to have to take on that risk because of the cost considerations. And hopefully, Nicole, you can send around some of these slides because I won't be able to get to all of them right now. But one thing I will end on here is the biggest thing I find as an issue with companies that I'm working with is termination. A lot of times people get into agreements with companies and they don't think about how the agreement's actually going to terminate. But when you do pick up an agreement with another company, it is the termination clause ends up being the most important clause. So give a lot of thought to, you're all excited working with this new collaborative partner, but when things go south, what does that look like? And make sure you don't forget about how does this agreement actually terminate, and put some thought into that.
Wow, well, thank you so much, Natalie. That was absolutely amazing. So much information and so many things to consider.
I know, it's too much time in an hour. I probably need an hour and a half, but yeah, so we didn't talk too much about sort of the IP considerations from the point of view of legal agreements, but there's just, getting IP assets is one issue, but then you've got to also think about how you're managing your agreements as well. So if anyone has any questions, just shoot me an email.
Oh, absolutely, for sure. And I'm happy to share your presentation with those who registered so they can look through it for sure. And I'm sure they'll have questions of their own. But speaking of which, I know we're at that almost 3 o'clock mark, but are there any questions from our those who are sitting with us right now? If there's any questions, now would be the time to write it in your chat box. And I'm sure Natalie will be happy to take a few minutes just to answer that question for you. So don't be shy to do that. I do have a little bit of a question just out of curiosity. When you're talking about trademarks, the TM as opposed to the R, right? Mm-hmm. So the TM, now the only time we can use that is if you've actually put in for a trademark application, or can you just do it?
No, that's it. Yeah. So TM, you can use that right away. So if you have a business trademark and you haven't filed for registration, you can still use the TM because you have rights. I mean, getting into more details here, you have rights at common law, and also in some jurisdictions, it's important to show the consumer that you are asserting it as a trademark. So I would definitely mark all of your logos and brands. I would put the little TM in the right-hand corner. You don't have to file for a trademark application to use that. It's the R with the circle that denotes that it's a registered trademark. So you can only use that once you actually have a registered trademark in that particular jurisdiction. So just be mindful of that. If you have a registered trademark in Canada, you can put it on your products you're selling in Canada, your services you're selling in Canada. But if you're selling into the US, you would need a registered trademark there in order to use the R. But you could use the TM in the US until you get your trademark registration. And you don't, I mean, the thing is with trademarks, you don't need to file for registration to have protection, but it is a good idea. And it gives you additional rights that you wouldn't have necessarily at common law. And in some countries, there is no common law rights for trademarks. But yeah, so that would be, I would definitely encourage, it shows companies a certain amount of due diligence. It's the same thing with the copyright. For all your material, put the C with the circle, the company name, like the author or the owner, and the date, so the year. So to 2020, and then the next year you put 2020 to 2021 if you updated the content next year.
Okay, well that's great, and there doesn't seem to be any questions. There's so much to process. I'm sure that.
I normally don't, when I do this presentation, I don't normally talk about sort of the IP action plan. I thought that would be faster than it was. So my apologies on that. I normally just give a presentation on IP, but that intro on the new economy took a little bit longer than I expected. Anyway, but I'm happy, as I said, I mean, I get a lot of questions as a follow-up. And so if you have questions about IP assets, or you have questions about legal agreements to do with IP, happy to answer basic questions. Answers to questions are free. And then if it's something more substantial, then of course, you know, people can go on a retainer, but I'm always happy to just answer questions.
Okay, perfect. Well, thank you so much, Natalie, for all of this.